Division 6 of the Court of Appeals. My name is Judge Furman. This is Judge Fox and Judge Ashby. We have one case set on the docket, People versus Trujillo. I see counsel are ready to go. If anyone in the courtroom has a cell phone, please make sure it's off, and you're both experienced. Let's just get started.
May it please the court. My name is Inga Nelson, registration number 47620, and I am a public defender today appearing on behalf of Ms. Trujillo. In light of the question received from the court, I plan to start by addressing the remedies available to the court, unless you have questions regarding whether it was error for the district court to refuse to disclose the documents it relied on to order restitution, which you would like me to address first.
Why don't you talk about the remedy first, and then
Great.
if we have time, we can get to the other issues.
Great. If this court agrees that it was an error for the court not to disclose this information, this court has basically two possible remedies. First, this court can vacate the challenged portion of the restitution order, and that is because the prosecution did not meet its burden to establish that the claimed lost wages were proximately caused by Ms. Trujillo's conduct. This court has held in Bond and the interest of KM that the fact that the board paid a claim is not itself determinative of whether restitution should be ordered, and the prosecution still must show by a preponderance of the evidence that the crime victim's loss was proximately caused by the defendant's conduct. The prosecution here relied solely on the documents that were held confidential by the board, and that is the only thing that they presented to support their claim for restitution. Based on what I have available to me in the record, it does not appear that those documents would prove that causal link, that Ms. Trujillo's conduct caused Mr. Martinez to be unable to work for however many days that he was reimbursed for lost wages. The prosecution presented no evidence to explain how Ms. Trujillo's conduct caused him to be unable to work, and the other evidence that is in the record would dispute that. Mr. Martinez was treated very briefly and released at the hospital, and he appeared in court 2 days after the incident and described his injury as a superficial scratch. Based on that, and I think based on this court's review of the sealed documents, you could find that the prosecution did not prove its burden to show that the injuries were approximately caused by Mr. Trujillo.
Counsel, did either party suggest to the trial court that there could be a middle ground between, complete non-disclosure and full disclosure, something in between where redacted portions of the documents were made available to defense counsel, or some sort of order limiting or restricting access to counsel could have issued? I mean, did anybody suggest some remedy other than the two?
Initially, the defense counsel was under the impression that the in-camera review would be held pursuant to how it was described in Rivera and how the statute at the time described it, which was with the presence of counsel. And so he did state that it had been his understanding that he would receive those documents and then be able to make arguments about whether they should be disclosed and discoverable for open court. No one really addressed that issue afterwards, and the trial court simply provided an inadequate response regarding why the documents were not discoverable in the court's mind for there to really be an opportunity to further discuss something like redaction. It's unclear why the trial court felt they were not discoverable.
So you've suggested to us that we can vacate. Would there be any benefit in remanding back to the trial court to conduct a new hearing?
Sure. I think the second option is that this court could remand to the district court with orders that the documents be disclosed and that Ms. Trujillo be given an opportunity to rebut those or explain them, such as is required by basic due process principles. So I do see those as the two options for remedies here.
So Ms. Nelson, sorry to interrupt. I wanted to find out, based on the language of the statute itself, at least as it existed, how do we know materials, or how does anybody know that they're discoverable based on the language of the statute?
Right. I mean, based on the language of the statute at the time, and
Right.
that's, of course, different from now.
Right.
The in-camera review itself contemplates a hearing or review that involves more than just the trial court. And so the way that I read this, and I think perhaps the reason why the legislature changed it, is because that in-camera review would involve a discussion with counsel, having an opportunity to make arguments regarding why it should be discoverable. So that's first. But second, it says that if the court does then conduct an in-camera review and determines that the materials are necessary for a resolution of an issue then pending before the court, then they are discoverable. And I think that
So-
provides,
So, sorry to interrupt. So that would be the trial court's call?
correct.
Okay,
Yeah, based on the statute.
right.
Yes.
That's what I was trying to figure out.
Yes, at that point.
I
And
understand.
I think then we would have a situation, much like we do with other forms of confidential documents, where on appeal, this court can review under seal, and that's the process that's discussed in cases like Frost and James, and review that decision to see whether or not the court made the correct call regarding disclosure. So I think that's the system that we've developed around that statute and other confidential documents. If you don't have any other questions regarding the error or other possible remedies, I would first urge you to vacate this portion of the restitution order, or alternatively remand for Ms. Trujillo to have an opportunity to rebut or explain whatever documentation is included in this.
May it please the court, I'm Christine Brady, registration number 24779, representing the people. This was not a complex restitution claim. The victim's estranged wife stabbed him multiple times with a kitchen knife when she was intoxicated. And although the victim originally tried to minimize his injuries to the police, when he became pale and cold and clammy, he decided he needed to go to the hospital, which they did call back the ambulance, and he did go to the hospital, and he was treated for his injuries, and then released. As a result of the injuries, he missed a week of work. So this is,
Counsel, can you tell me where in the record we have evidence of that causal link between the stabbing and his claim for lost wages?
well, actually, the medical injuries that happened, we don't have that in the record. The defendant decided not to contest those and decide to pay those, and then did not make that part of the record. This information, though, that what I just talked about, it was verified by the Victims' Compensation Board before they paid the claim, obviously. They contacted the employer directly, separate and apart from the victim. And the trial court made its findings, and of course, this court can review what's in the sealed records to make sure that the trial court's findings are supported in there. All of that is the due process, and it's a three-tiered process with the VCB verifying, the trial court making its findings, and then, of course, this court can review that and make sure that what's in the documents are supported by the findings.
But-
Go ahead.
But what's the means by which the defense is able to challenge the validity of the findings made by the trial court? If we do as you suggest, aren't we effectively saying so long as the trial court thinks that there, and the board believes that there's a basis to award, then there's no opportunity to challenge that finding?
Well, in this circumstance, the trial court was able to verify what the VCB had decided. And if the documents, in fact, verify the trial court's findings, then this court can decide to affirm them.
And what if they don't? What do we do?
Right, so in regard to the remedy that this court has asked about, if for some reason there's something in the documents that was not disclosed by the court, that is something that is challengeable, that maybe might show that the victim's claim, there was some, reason to contest the victim's claim, then the court can, number one, find that it's harmless if, in fact, the findings are,
But how can it be harmless if that the information would have allowed the defense to challenge that portion of the restitution award? I mean, how can it possibly be harmless? It may not be a lot of money, but it may be a lot of money to this particular
Sure.
person.
Sure. It can be harmless if the trial court's findings are supported by what's in the record, even though this court might find that, okay, these documents should have been disclosed. The court made very simple findings, right? The victim suffered these injuries. He was treated for these injuries. He missed work right after that. He might have just thought, I don't feel good. I can't go to work this week. That's something fairly subjective, and that's something that's within the trial court's discretion.
Yeah, but the trial court focused on correlation. His missing work was correlated to when his injuries occurred, but we don't have anything showing causation. That's the link that I'm struggling with.
Okay. Yeah, well, I don't know. When you're stabbed, maybe it's just psychological. If the victim had been called at this hearing and said, I just didn't feel good, or I was traumatized because because my wife stabbed me, I think that would be good enough. And of course,
But the prosecution didn't do that.
well, the prosecution didn't have to do that. The defense could have subpoenaed the victim.
Well, Ms.
I'm sorry,
Brady,
the defense, I didn't hear what you said. The defense should have,
No, I didn't say the defense should have. They could have subpoenaed the victim and said, well, why did you miss this week of work? And they didn't do that.
so Ms. Brady, what I'd like you to answer is the question that I asked Ms. Nelson. How does this, under the old language, the statute envision discoverable material? How does, walk me through that, if you would.
Well, there's not a lot of guidance there, and I think
noticed.
that's, yeah, I agree, Your Honor, and there's not a lot of guidance there. And I think that's why the new provision of the statute, which became effective 3 weeks after this hearing, says that, once the VCB the victim's compensation.
Well, go back to the old, because
Okay.
walk me through that, if you would.
There's really nothing there that
But it's a trial court call, essentially.
Yes, it's total discretion at that point, yes.
Okay.
And, just in closing, the VCB did nothing wrong here. They shouldn't be deprived of their $1,000 if, when this court reviews the sealed record, that they find that the evidence supports the award. Thank you.
very briefly. First, to your point, Judge Furman, regarding the statute, the language is, if it's necessary for determination of an issue pending before the court. I think in this case, the documents were the sole evidence that the court relied upon to make that determination of the restitution order. So there's no question that they were necessary for a determination of the issue that was pending before the
And you're,
court.
sorry to interrupt, you're basing that on the trial court's findings?
Yes, and the fact that that's the only evidence that was presented to the trial court upon which they could have made a decision, and the fact that the court repeatedly cited those documents and in the court's orders. And there was quite a bit of discussion for restitution on this. Secondly, I would just like to address this court cannot simply affirm the order based on the undisclosed documents, because that does not cure in any way the due process violation. The reason why a defendant has a due process right to notice of evidence to be used against them in sentencing is because the testing of evidence in the adversarial process is key to ensure that a person is not sentenced based on materially false information. And simply affirming would give no opportunity for us to test that in any way, shape, or form. Similarly, it can't be harmless for the same reasons. Thank you.
All right, thank you, counsel, for your excellent arguments. The case will stand submitted and a written opinion will issue in due course.